Hi, I'm Sara Bronin, and I am created this Property Law 101 series to help you learn a little bit about the basics of property law. We have categorized our sessions into four big categories covering four questions in law, and today we're covering the third one, which is using property. And we are focused on covenants. So a covenant, a type of servitude, which we've considered in another video, but a covenant is a legal agreement between private parties that runs with the land. Generally, that means covenants burden successive owners. Again, they are not created by the state. They might be agreed upon by successors in interest. They might be agreed upon by like-minded condo owners. They might be created by developers building subdivisions, so large residential areas that might eventually be governed by homeowners associations. Covenants are not exclusively residential, I should say, but we focus a lot in our cases and in our discussion on residential covenants. So covenants on properties. So what do they say? There's a few things that typical covenants say. So a covenant might articulate what kinds of improvements you can make to your unit, to your property. For example, if you're within a homeowners association or a condo unit, it might say that you can change the wallpaper or change light bulbs, but that you have to get permission from an association to move plumbing or make major changes or to change a supporting wall or to alter the exterior of the building. Covenants might also impose limits on the number of people who can live in the house and their relationship to you. There might be also procedures established in covenants for things like architectural review of interiors. So how are covenants like and unlike easements covered in other videos in this series? So covenants like easements allow neighbors to deal with the external costs of conflicting resource use. However, there are differences between easements and covenants. Unlike easements, covenants are always express. Covenants are subject to the statute of frauds, much more strictly applied to covenants than to easements. As we've discussed in other videos, easements can sometimes be implied or they can be created through estoppel, even without a writing. Also, unlike easements, covenants often involve many different people. They often burden an entire neighborhood under the same rules, but still more than just two parties. In an easement, it's usually just two parties, maybe a handful more, but again, often a servient owner and a dominant owner, and that's about it. One of the old doctrinal questions in the law of covenants, one that is growing less and less important over time, is whether a covenant, whether the promise is an equitable servitude or a real covenant. I don't spend a lot of time on this in property class because these two strands of covenant theory are merging into one area, almost as if there's no distinction between law and equity anymore. But I flag it as a point of interest and possibly as a continuing item on the bar exam. One of the significant questions in covenant litigation is whether the covenant runs with the land. So this is one of the requirements of traditional covenant law. In other words, do the covenants bind just the original parties to them, or do they create property interests that attach to particular parcels so that they burden and or benefit successor owners? A court might look at the intent of people entering into the covenant in trying to answer this question. It might look at the requirement that the covenant touches and concerns the land. It might also look to privity. This is a concept that's pretty familiar to you, I would assume, through contract law. But again, privity is about the relationship between parties and whether they have a special bond through perhaps something like a real estate transaction or some other arrangement or relationship that demonstrates that the covenant should bind people beyond the original parties. So there is the traditional requirements for covenants that we've just briefly touched on here. Courts apply some or all of these in sometimes confusing ways. So I encourage you to consider the approach of the third restatement of property, which is covered in another video in this series. And through the third restatement, you might find clarity that you don't find in the requirements for covenants that are traditionally set out in legal doctrine. So I'm going to leave it there. I would love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.